But how is it visible? Is it visible on the entire screen?
No, ma'am. It's not visible full screen.
All right. Anyway, um, I won't be able to look at the questions if you type your questions in the chat box. So I will request Manya to please keep a track of any questions that participants may type in the chat box. All
Sure,
right.
ma'am. Ma'am, I'll be there. Yeah. Yes, ma'am.
Okay. So starting with a very basic question as to what IP entails or what IP means. I'm sure a lot of you would answer or a lot of you would know that IP is nothing but the creation of your mind. So if you look at your life, you are surrounded by a lot of devices or a lot of things that perhaps will have one or two or many more IPs. So the phones that you use, the laptops that you're using, the movies that you watch, the songs that you listen to, the books that you read, the notes that you make, the pictures that you click. So each and everything comprises of some sort of IP, and this is where the relevance of IP becomes important for an individual like us. So since on a daily basis, if in case we are involved in creating something or in case we are using someone else's creativity, then it becomes important to understand that how law plays a role in regulating your behavior as far as using a particular IP is concerned, or in case you're the creator itself, then how can you enforce your rights? All right. So IP is nothing but the creative efforts from the human intellect. And that's the reason it is known as intangible asset. Tangible asset, तो I'm sure सबको पता है that so far we understand that land property or something that can be seen or something that can be perceived is considered as your asset. Okay, तो आप जैसे factories देखोगे या manufacturing plants देखोगे, so the understanding of property, traditional understanding of property is that something that can be owned, land, house, car, anything which can be seen or perceived. But with time, as the society grew or as our inventions or our understanding of science grew, we shifted our understanding from tangible assets to intangible assets. All right. So that comprises of technology, that comprises of any creativity that can have some economic benefit, or that can give you some economic benefit by exploiting that particular creativity or technology. So look at these big companies, look at Google, look at Apple, look at big brands like Nike or Adidas or Netflix or Amazon Prime. All right. So all these kind of businesses are actually thriving on IP. So how are they thriving on IP? So either they are themselves creating something. So let's say Google comes up with certain technology or certain software. So they can license it and make money. They can sell it and make money. Similarly, Netflix or Amazon Prime. So if I create a movie and I enter into a contract with Netflix, then there is again a bargain. There is again a transaction of money or content that is created. Similarly, if there's Nike, there's Adidas. So what you're buying from Nike is not just the clothes or the shoes. You're actually buying a lifestyle. You're actually buying a reputation that is associated with Nike. So you rely on the quality, and that's how you buy things. So all these businesses are actually based on strong IP, and that IP could either be uh, a patent or a copyright or a trademark or a design. So this is where the different categories of IP come into existence. So a lot of layman would not know that there are several or multiple types of IP. We usually use the same term to refer to any IP. आपने भी सुना होगा, हर कोई बोल देता है मैं इस लोगो पे पेटेंट ले लूंगा या मैं इस फिल्म पे पेटेंट ले लूंगा, and that's the most common thing I've heard. And I'm sure you all use this, or you must have also heard these kind of things. But there are different categories of IP, and we have to use the word carefully. कि हम अगर किसी book को refer कर रहे हैं, then it would be right to say that I have a copyright over a book. पर अगर हम किसी टेक्नोलॉजी को रेफर कर रहे हैं, then the right thing to say would be that I have a patent over this technology. And if you're talking about a trademark or a logo or a brand, then it would be right to say that I have a trademark over this logo or over this slogan or over this sound mark and so on. All right, so there are different categories of IP depending upon what have you created. All right, I'll come to that. The next point would be that जो भी लॉ गवर्न करते हैं आईपी को, वो सारे legislations talk about a few things. One would be that what is the subject matter of that particular legislation. So let's say we have Trademarks Act of 1999 or Copyright Act of 1957 or Patent Act of 1970. So patent will talk about inventions. Copyright Act will talk about films, music, drama, literary work, etc. Trademark will talk about logos or a mark or a sound mark, color mark, and so on. So every legislation will talk about the subject matter, and then it will also talk about कि जिसने भी उस subject matter को create किया है वो अपने rights को कैसे enforce कर सकता है, वो अपने rights को कैसे और how can that person commercialize his or her IP. The another point would be regarding registration. Okay, so I'm sure you all must have heard कि मुझे ट्रेडमार्क फाइल करना है या मुझे इसके लिए एप्लीकेशन फाइल करनी है, कॉपीराइट फाइल करना है तो ही मेरे राइट्स प्रोटेक्टेड होंगे एंड सो ऑन. सो एज फार एज रजिस्ट्रेशन इज कंसर्न, विद रिगार्ड टू रजिस्ट्रेशन ऑल्सो इट डिपेंड्स व्हाट काइंड ऑफ आईपी यू आर टॉकिंग अबाउट. ऑलराइट, तो कुछ आईपी में रजिस्ट्रेशन मैंडेटरी होता है, कुछ आईपी में रजिस्ट्रेशन मैंडेटरी नहीं होता है. सो लेट्स से अगर कोई टेक्नोलॉजी या इन्वेंशन की आप बात कर रहे हैं and you're talking about patent law per se, then Patent Act of 1970 mandates that you must get your technology or invention registered before you launch it in the market. But when it comes to Copyright Act of 1957, the Copyright Act registration mandate nahi karta hai, which means the moment you create something, moment you click a picture, moment you create a song and you publish it, from that date it will be considered as yours. You need not to get anything registered formally under Copyright Act. And similarly, under trademark law also, registration of the trademark or the logo is not mandatory. However, it is advisable that you take registration over your creations because it then becomes easy to prove your ownership. Another point is time bound. So once you know whether you have to get it registered or not registered, so every registration or grant of registration is limited for a particular period of time. So let's say patent अगर आपको मिल जाता है आपके invention पे, so you get a registration for 20 years. After 20 years, anyone can use your technology. So let's say there's a technology that is used in a washing machine. All right. So washing machine, आप कोई washing machine बनाते हैं जो washing machine आज की date में can wash clothes and dry clothes in 20 minutes. All right, so let's say there is some invention which is involved in your washing machine and you get a patent over it. So you will have the exclusive right to use that invention or technology for 20 years. After 20 years, आपने जो भी invention या जो भी technology आपने use की है अपने washing machine में, that will be in public domain and anyone can use it and sell it. All right, so every IP is time bound, which means हर एक आईपी का एक लिमिटेड टाइम पीरियड है, उसके बाद वो आईपी पब्लिक डोमेन में आ जाएगा और उसे कोई भी यूज कर सकता है. So like patent is for 20 years, trademark is for 10 years, which can of course 10 years के बाद भी आपसे renew करा सकते हैं. Copyright is for life of author plus 60 years, 70 years, depend upon the creativity or type of creativity. Next point is territorial. Territorial का मतलब हुआ that your legislations or your rights can only be enforced within India. All right. So every IP is territorial in nature. तो trademark law जो है वो applicable होगा इंडिया में, copyright भी applicable होगा इंडिया में, patent भी applicable होगा इंडिया में. So there's nothing like कि मेरे पास patent है पूरे world में. Okay, so I can't really say that I have a patent over this technology throughout the world because that's not possible unless you have actually filed your application in every individual country and have got a registration. All right, so there's nothing like international IP or international patent or international trademark or international copyright. You have to comply with the requirements of every individual country. However, um, more or less, countries have a lot of similarity as far as their legislation is concerned. And why is there a similarity? The similarity between legislations exist. So if you look at US law, or if you look at Indian law, or if you look at UK law, आपको बहुत सारी similarities मिलेंगी in legislations में. And why is that so? The answer to this question lies in the fact that there are international conventions. Okay. Now, what is an international convention? International conventions are basically agreements which are signed by states or countries. Okay, so let's say हम जितने भी लोग यहाँ present हैं, हम सब लोग एक एक country को represent कर रहे हैं. Okay, so let's say Manya is in UK right now, so Manya is representing UK. I'm representing India and some one of you representing US, कोई Germany को represent कर रहा है, कोई China को represent कर रहा है. And then we all discuss and decide कि हम कुछ minimum guidelines हैं या principles हैं वो follow करेंगे when we make our own legislation. All right. And the idea behind these international conventions is to ensure that every country follows certain minimum guidelines. Okay. ऐसा नहीं होना चाहिए कि इंडिया बोल रहा है कि मैं पेटेंट सिर्फ 5 साल के लिए दूंगा और चाइना बोलता है कि मैं पेटेंट 30 साल के लिए ग्रांट करूंगा एंड यूएस सेज that we'll grant patent for 40 years. So to avoid such discrepancies or such different, parameters or such different approach towards IP, international conventions are signed by member countries to ensure that we know that what kind of rights can be enforced in different jurisdictions so that there's a uniformity across the globe or across the countries who have signed those international conventions. All right. So there are a lot of international conventions that specifically deal with different IPs. Okay. Now I'll tell you what are those international conventions. So, uh, so with respect to copyright and related rights, copyright may, as you know, books, dramatic works, films, songs, and so on will come. So for this, you have a specific international convention, which is known as Berne Convention for the protection of literary and artistic work. Okay, so this is a specific international convention which deals with copyright and related rights. So let's take one example. So the Berne Convention says that the rights on a given novel will be given for life of author plus 50 years. So the convention says कि minimum आपको इतने rights और इतने duration के लिए rights देने पड़ेंगे. Okay, so if let's say we all agree to this, तो हम सबको जो भी हमारे country में किताब लिख के publish कर रहा है, we will have to give them rights for life of author plus 50 years minimum. It can be more than 50 years. So let's say India grants rights for life of author plus 60 years. There might be chances that US grants rights for life of author plus 70 years. There might be chances that Germany grants rights for life of author plus 50 years. All what is required is that you follow the international convention, the minimum mandate. All right. That's where the international convention becomes relevant so that we all follow minimum guidelines. So with respect to copyright, the convention is Berne Convention for the protection of literary and artistic rights. Then comes patent, trademark, and designs. And these together are popularly also known as industrial property. Okay, copyright को हम non-industrial बोलते हैं because their the objective of legislation is actually to reward the creator rather than to apply it in the industry or commercialize it in that sense. And hence the reason copyright is known as non-industrial law. Whereas if you look at patent, trademark and designs, इसको थोड़ा हम industry या utility के perspective से ज़्यादा देखते हैं. That what is the utility of a particular invention or a particular design or a trademark. So we try to associate some sort of function with an invention or a logo or a design. Okay, hence the reason these are known as industrial properties. And cumulatively, all these industrial properties are dealt under Paris Convention. Okay, so Berne Convention is for copyright laws, and Paris Convention is for patent, trademark, designs, and so on. Now, apart from these two broad categories, there are certain other, IPs as well. For example, trade secret, okay, or confidentiality or know-how of a business, traditional knowledge, and so on. So these are those kind of IPs for which you may not have specific international conventions. Nonetheless, they are considered as IP to some extent because it talks about your or human creativity, and hence the reason. So there's a lot of, I'm sure you all know, there's a lot of debate that goes around protecting traditional knowledge under IP. That, for example, neem ka paste, okay, whether it can be used in medicine or not. Should we be sharing the benefit of that particular medicine with a country from where that traditional knowledge comes, and so on. So traditional knowledge is one thing where there's a debate that keeps on happening as far as considering traditional knowledge under IP or not. But for you as of now, what you need to remember is two broad categories of IP. One is copyright, which is dealt under Berne Convention. The other is patent, trademark, designs that comes under Paris Convention. Okay. Any questions so far?
Uh, Ma'am,
Is there any
like,
question?
no, they are not question as such, but one of the question is what can be considered as a principle of IP?
Principle of IP. Okay. See, principle of IP is basically that it is a contract between the creator and a sovereign state. So this is really theoretical in nature, that when you create something and state agrees to grant you certain rights on the condition that you disclose your creativity with the world. So if I've written a book, I should publish it. All right. If I have an invention, I should make it put to use so that every other person can use it. It should have some industrial application. Only then your rights will be protected, or some grant rights will be granted to you. So it is a sort of a contract between the creator or an inventor and the state. All right. So that is what the basic principle of granting rights under IP regime or IP understanding is. Okay. And another thing that is important for you to understand is that there are certain exceptions also under the law. Under the law, exception in the sense that it is not that your rights are exclusive. Exclusive in the sense that no one else can use your work under any circumstances. So that would not be the case because law will always have certain exceptions. Exceptions in the sense, let's take for example, ki, if I share certain articles with you, or if I share certain extracts from a book with you for understanding what IP is, so if I take a photocopy or if I scan something and I share it with you, then it will not be considered as any kind of IP violation because it will come under exception. Otherwise, you can't really scan books, you can't really share articles with anyone unless you have a license to share or you have some sort of consent from the author to share his or her work with the public at large. But since there are exceptions under the law, and in education, for educational purpose, I can share certain things with you and it will not be considered as any kind of infringement. It will come under exceptions. Okay, so there are a lot of exceptions that exist under any law, be it patent, trademark, or copyright. Any other
So ma'am, I can
question?
see a
Yeah,
yeah, I can see a hand raised by
that
Shivam
would be great.
Chaturvedi.
Yes, Shivam.
Yeah. Uh,
Good evening,
Shivam,
ma'am. Am
go
I
ahead.
audible?
Yes,
Yes,
Shivam,
you're
you're
audible.
audible. Please go ahead.
Ma'am, so you spoke about the Berne Convention and several other statutes that are present in India.
Yeah.
So, for example, Apple or HP, Hewlett Packard. So,
Mhm.
which laws do they abide by when they are bringing their products into India? Because they are specifically a foreign company.
Okay.
So,
Mhm.
this is a confusion from my side that
Yes.
which, yeah.
See, Shivam, when there is, see, now it can involve a lot of legislations, in not just IP that may come into picture. राइट? कभी भी कोई भी टेक्नोलॉजी ट्रांसफर हो रहा है या फिर सिर्फ प्रोडक्ट्स आ रहे हैं कहीं से बाहर इंडिया, सो बहुत सारे लेजिस्लेशन अप्लाई हो सकते हैं, कस्टम्स लॉ भी एप्लीकेबल होगा, ओके। बट अगर हम इसको बहुत उसको थोड़ा सा नैरो कर दें एंड इफ वी ट्राई टू अंडरस्टैंड इट फ्रॉम द आईपी पर्सपेक्टिव, सो यू हैव टू बी मोर क्लियर इन योर क्वेश्चन एज टू कि एप्पल अपने सिर्फ प्रोडक्ट्स लॉन्च कर रहा है इंडिया में, राइट? लेट्स से आईफोन आता है और एप्पल आईफोन इंडिया में लॉन्च कर रहा है, लेट्स से आईफोन 15 आ गया, ओके। नाउ हाउ कैन एप्पल प्रोटेक्ट देयर राइट्स? दैट शुड बी द क्वेश्चन as far as IP is concerned. So in that case, अगर एप्पल में कोई भी नई इन्वेंशन यूज की है for iPhone 15, so Apple should get it registered in India as well. Okay, because our patent laws, Hamara Patent Act of 1970 requires that you should get your invention registered before you launch it in the market. And again, we are going back to the same thing, territorial in nature. IP laws are territorial in nature. So we have to look at, or you have to comply the legislation of the country in which you're going to launch your product. Right? Does that answer your question, Shivam?
Yes, ma'am.
Okay, but patent के केस में है ऐसा. But let's say copyright legislation. अब copyright legislation जो हमारा act है, it does not mandate registration. So you can launch it even without filing for an application in India. But there might be a case that some other country requires that even under copyright law, registration is mandatory. So as a creator or as an inventor, you have to, this is your, this is the work of either the creator or the inventor or your lawyer to ensure कि आप जहां भी अपने product को launch करना चाहते हैं, it may be an invention which falls under Patent Act. It may be a book or a film that comes under copyright law. It may be a brand जो logo आप launch करना चाहते हैं, Trademark Act. So you have to look at from the country's specific country's perspective कि US में क्या requirements हैं. अगर आप उसको चाइना में लॉन्च करना चाहते हैं तो आपको देखना पड़ेगा चाइना में क्या रिक्वायरमेंट्स है, ओके। यू कैन नॉट अज्यूम कि अगर इंडिया में रजिस्ट्रेशन मैंडेटरी नहीं है तो शायद चाइना में भी मैंडेटरी नहीं है या चाइना के भी रिक्वायरमेंट सेम ही होंगे। ऑलराइट, सो दीज लेजिस्लेशंस आर टेरिटोरियल इन नेचर। अगर आपका प्रोडक्ट इंडिया में आ रहा है तो इंडिया के एक्ट्स लगेंगे, कॉपीराइट, पेटेंट, ट्रेडमार्क। अगर सेम प्रोडक्ट आप यूएस में लॉन्च करना चाहते हैं तो आपको देखना पड़ेगा यूएस का लेजिस्लेशन क्या बोलता है। ऑलराइट शिवम?
Yes, ma'am. Thanks a lot.
Okay.
So ma'am, we have a few questions more.
Yeah.
So one of the question by Satyam, ma'am, for the author, can he file the application in other country where he has highest protection?
You cannot do that on here.
Okay. Let me just read the questions on my own because it seems Manya is in the library and she's not allowed to speak loudly. Okay. Where do I see the questions? In the chat box? Okay.
Ma'am?
Yes.
Yeah, so my question was the author, can he file a application where he gets the highest protection, like in another country?
Of course. But why do you ask that question? Tell me. I mean, how is it going to benefit you?
Like if in India it gets 20 years after, and in other country if it's 50 years, so it's more beneficial, right?
But that will be applicable only in the other country. So you
Okay,
can't
okay.
say कि मैंने यूएस में गया और मैंने वहां registration ले लिया and their registrations for 50 years. So India should also give me rights for 50 years. That can't
Okay.
happen.
Uh-huh.
Again, yeah. Again, going
Yes.
back to Shivam's question, IP laws are territorial in nature. But as I said, there are international conventions, right?
Mm-hmm.
बहुत ज्यादा डिफरेंस नहीं मिलेगा आपको, इतना डिफरेंस नहीं मिलेगा कि कोई 20 years के लिए राइट्स दे रहा है और कोई 50 years के लिए राइट्स दे रहा है. So you won't find that kind of difference. And thanks to our international conventions that have laid down कि minimum आपको इतना follow करना पड़ेगा. Okay.
Sure.
So if you look at Berne Convention, so copyright में usually minimum what is required is life of author plus 50 years. तो अगर आप legislations compare करेंगे of major countries like US, UK, India, China, you'll find it is between 60, 70, 50, 60, 70, 50. All right?
Yeah, sure, ma'am. Thank you.
Okay. Let me take a more questions. Mansi ने question पूछा था, what is the IP for music? Can anyone answer me this question? कि music किस category में fall करेगा?
Copyrights.
Copyright, exactly. ठीक है? So copy, I'll repeat it again for you. Copyright का subject matter होता है कोई भी creativity ले लो आप. Let's say आपने किताब लिखी है, आपने poem लिखी है, आपने music lyrics लिखे हैं, आपने गाना बनाया है, आपने film बनाई है, और क्या हो सकता है, पेंटिंग की है आपने, आपने पिक्चर क्लिक की है, आपने स्कल्पचर बनाया है, एनीथिंग दैट involves some sort of creativity. Okay, so music comes under copyright legislation. Okay. Ahmed ka question hai, how can someone apply for patent? Ahmed, are you there? Ahmed, are you there?
So ma'am, I think this question can be addressed like later on in the pattern session.
Yes, exactly. So Emma, this since it talks about the procedure for filing, so this will be addressed in the patents section. Mangalam Sharma, I think I've answered that question. Satyam, Devendra. Okay, Devendra ka question hai, how can someone register copyright if he or she want to, as there is no specific provision related to Copyright Act, it is in the act. Okay. Alright, so Devendra, it's not that कि law में ये नहीं लिखा है कि आप file कैसे करोगे. So there's definitely a procedure to file for copyright. If you check copyright office का website, online अगर आप Google करोगे copyright office का website, you'll find the procedure there, and the procedure is also given in the Act, Copyright Act of 1957. It's just that law does not mandate कि law ये नहीं बोलता कि अगर आप registration नहीं लोगे और अगर आपने बुक रजिस्ट्रेशन से पहले ही लॉन्च कर दी मार्केट में तो हम आपके राइट्स प्रोटेक्ट नहीं करेंगे. ओके, सो दैट इज व्हाट will be the implication of either making it mandatory or making it not mandatory. Okay, so you have to understand from a legal point of view कि अगर कोई legislation बोलता है कि registration कराना जरूरी है, must है, या फिर कोई legislation बोल रहा है जरूरी नहीं है, तो इन दोनों का मतलब क्या हुआ, लीगल इम्प्लीकेशन क्या होगा, राइट? तो लीगल इम्प्लीकेशन ये होगा कि अगर एक लेजिस्लेशन बोलता है रजिस्ट्रेशन कराइए पहले तब मार्केट में लॉन्च करिए, इसका मतलब ये हुआ कि अगर आपने रजिस्ट्रेशन नहीं कराया तो आपको अपने राइट्स इन्फोर्स करने में प्रॉब्लम आएगी. कोर्ट ये बोल सकता है that since you did not get your rights registered or invention registered, we can't help you. Right? कोई भी कॉपी कर सकता है आपके इन्वेंशन को, बेच सकता है, हम कुछ नहीं कर सकते. ये पेटेंट में होता है, बट कॉपीराइट में ऐसा नहीं होगा, ट्रेडमार्क में भी ऐसा नहीं होगा, क्योंकि लॉ मैंडेट नहीं करता है रजिस्ट्रेशन. बट बहुत से लोग रजिस्ट्रेशन कराते हैं बिकॉज देन इट बिकम्स इजी टू प्रूव ओनरशिप. राइट, इसी को अगर थोड़ा और स्ट्रेच करेंगे, लेट्स से चाइना इज नोन एज कि वहां पे हर चीज का डुप्लीकेट या मास्टर कॉपी या ट्रू कॉपी मिल जाएगा, एंड फॉर दैट मैटर इवन इन दुबई एज वेल, राइट? सो नाउ एज अ क्रिएटर आई हैव टू बी वेरी विजिलेंट कि मेरा प्रोडक्ट कहाँ पे कॉपी हो सकता है, वहां पे तो रजिस्ट्रेशन लेना जरूरी है. Right, so again it's a decision that you have to make as a businessman or as an entrepreneur, that where is my market, where should I get my rights registered. Of course you will not get your rights registered in every country of the world, that does not make sense, right? जहाँ पे शायद लोग आपका प्रोडक्ट खरीदेंगे भी नहीं, और जहाँ पे कोई पायरेटेड कॉपीज भी नहीं बनेंगे आपके प्रोडक्ट के, वहाँ आप it does not make sense to go and file application and get it registered. But look at where your market is, where there are possibilities that your product or your creativity or invention might be copied. So those are those markets, those are those countries where you should get your rights registered. All right? Okay. Chirag ka question hai, what is the reason for copyright protection for lifetime plus 50 years? Chirag, see, again, going back to Chirag, are you there? It would be great if I can see you also, because then it becomes easy.
Yeah, I'm there,
You're
madam.
there. All right, great. So, see, copyright, as I mentioned, the objective of copyright law is to basically reward the creator, right? Unlike patent, trademark और designs जहाँ पे हम देखते हैं utility क्या है आपके product की, मतलब वहाँ भी हम reward तो कर ही रहे हैं जब आप rights दे रहे हो, but copyright का sole objective यही था that these are, you know, artists, these are not manufacturers, these are artists, so their rights should be protected, and that's why it is for a very long duration कि author की पूरी lifetime plus 50 years. All right. There's no specific reason as such ki why is it only 50 years, 60 years or 70 years, but it is considered that this time would be enough for you and your coming generation as well to recoup your investment or to enjoy that ownership or that property. Okay. Hence the reason to some extent that is considered as copyright protection lifetime plus 50 years. ओके और बहुत सारे डिबेट तो ये भी एग्जिस्ट करता है दैट व्हाई शुड इट बी ओनली 50 इयर्स इट शुड बी लाइफ टाइम एंड विदाउट एनी लिमिटेशन टू नंबर ऑफ इयर्स बिकॉज इट इज एक्चुअली माय क्रिएशन it will have my impression, so there should not be any limitation even under copyright laws कि lifetime तो है ही उसके बाद ये 50 years 60 years 70 years का limitation भी नहीं होना चाहिए. Okay. All
Okay.
right. Aranya, can we protect ornamental objects under IP? Yes, Aranya, definitely. So I'll take this question and I'll try to answer it from a different perspective as well. So there are different, sometimes it might happen कि same subject matter दो different legislations में fall कर रहा है. Okay, Aranya, are you there? Yeah, great. Okay.
Yes, ma'am.
Okay, so firstly tell me what do you think ornamental objects artistic work है copyright में आ सकते हैं?
ये मैम कॉपीराइट भी आ सकते हैं एंड सेम अदर से लोगो भी जो होता है वो ट्रेडमार्क पे भी आ सकते हैं जो
नहीं
हर
ornamental आपने
मैम हर
ornamental
ऑब्जेक्ट
objects बोला है.
जिसमें हर ऑर्नामेंटल ऑब्जेक्ट से कुछ खास डिजाइन लोगो होता है उस ज्वेलरी का तो वो
Okay.
ट्रेडमार्क पे भी आ सकते हैं वो चीज.
Okay. Yeah. So let's understand. Let's take an example. Let's say there's a piece of jewelry. ठीक है? कोई jewelry है. It may be a bracelet or something, earrings or necklace or something. So since it's an artistic work, it can come under copyright law. Okay. But you have another legislation as well, which is known as Designs Act of 2000. All right. तो जब भी हम कोई डिजाइन को आर्टिस्टिक वर्क को एक आर्टिकल पे अप्लाई करके बेचते हैं then it comes under Designs Act. All right. So
Okay,
say for
ma'am.
example, another example would be कि
मैम कौन सा ज्यादा इफेक्टिव रहेगा मैम ऑन दिस एस्पेक्ट?
I'm coming to that. I'm coming to that. So there's a long history behind this. Next question should be that if ornamental object already comes under copyright law, why do we need Designs Act? Right? Should this question arise in your mind?
यस
कि
मैम.
आर्टिस्टिक वर्क को कॉपीराइट में आ रहा है वो तो हमें डिजाइन एक्ट की क्या जरूरत है? So answer
Yeah,
is that, again going back to the objective, that the objective of copyright law is to reward the artist, right? कि artist हैं ये इसलिए इनको reward देना चाहिए. But जब artist ने उसको उस level पे commercialize करना शुरू कर दिया, when artists became manufacturers, all right? So now what you're doing, आपने पहले तो let's say आप design बनाते थे paper पे, या आप बड़े अच्छे artist थे. Now you started making jewelry and you're multiplying jewelry also. एक ही डिजाइन के आपने 50 pieces बना दिए, 100 pieces बना दिए, and you are selling it in the market. So now you are no more an artist. You have become a manufacturer. All right. And hence it was thought कि अगर आप artist नहीं हैं, अब आप manufacturer की तरह act करें, then it should be treated as an industrial property and we should limit the rights. So copyright में क्या है? Life plus 50 years, 60 years, depending upon the creativity. Designs Act में आपके rights मिलते हैं आपको सिर्फ 10 साल के लिए, which can further be extended for another 5 years. But it is only, let's say, 10 years. After 10 years, the design will be in public domain. So that's the difference between copyright and Designs Act. All right, Aranya, have you understood? Now
Yes,
your
ma'am.
next question was, which is beneficial, right?
Yes, ma'am.
Beneficial क्या होगा? See, अब ये तो हमें लगता है कि beneficial क्या, आपके हिसाब से beneficial क्या होगा? Copyright Act? क्योंकि वहाँ
Yes,
लॉन्गर
ma'am.
ड्यूरेशन है, ठीक है.
Yes, ma'am.
बट अगेन जिन्होंने भी लॉ लेजिस्लेशन ड्राफ्ट किया है, दे नो हाउ टू डील विद दिस सिचुएशन, राइट. इफ वी
Yes.
ग्रांट copyright for these kind of things, then the entire idea of Designs Act would be frustrated, right?
Yeah, ma'am.
फिर
Obviously,
Designs
ma'am.
Act का मतलब क्या हुआ? So that's the reason there is a provision under the Copyright Act that says कि अगर आपने वही डिजाइन को 50 टाइम्स से ज्यादा मल्टीप्लाई कर दिया, ठीक है, सो 50 इज लाइक द कैपिंग, कि अगर आपने 50 बारी से ज्यादा उसको मल्टीप्लाई कर दिया तो आप डिजाइन एक्ट में आएंगे, तो आपको कॉपीराइट का ड्यूरेशन का प्रोटेक्शन नहीं मिलेगा. योर राइट्स विल बी प्रोटेक्टेड अंडर डिजाइन एक्ट. ऑलराइट.
Yes, ma'am. Yes, ma'am. Got it, ma'am.
So your फिर आपके rights limited हो गए. And another difference between copyright and designs is copyright में registration mandatory नहीं है, but designs में registration mandatory है. So if the artist is trying to act smart by saying that my rights are protected under copyright and hence I did not get it registered, and you launch it in the market, you multiply it for more than 50 times, then you lose all your rights under Designs Act because that requires registration before launching it in the market. All right. डिटेल
Yes.
में पढ़ने के लिए फिर डिटेल में जाना पड़ेगा. Okay, let me take more
Okay, ma'am.
questions.
Okay, ma'am.
How can someone protect his or her business idea but still be able to discuss it with the others without copying them? Mangalam, are you there? Mangalam, are you there? There are a lot of questions. Manya, do we have the time to address all questions?
No, ma'am. Actually, Arushi ma'am is already here.
Okay. So what I can do is,
Actu-
can you send me the email of these or a screenshot of these questions? Maybe I can just type these questions, response to these questions and send them back. Or my advice would be that there are some questions that require deep understanding or deep discussion. So we would recommend you to register for the specialized courses and then we can discuss these things in detail. What do you think, Manya?
Yes, ma'am. And I think that most of the questions are very specific to like copyright, patent, and
Exactly,
trademark, and we'll be
exactly,
having
exactly.
sessions on them. Then after
Right.
that, people still have doubts, then we can address them over email.
Exactly, because there are a lot of questions and this will take another
Yeah,
hour to finish these
yeah, this,
questions. Right. So our idea
yeah.
is to just to introduce you to various kind of IPs and why is it relevant and so on. So, but these questions will need a lot of time for discussion. So anyway, you can anytime get in touch with any of us. You can write to us. And if you are interested, then we have our full-fledged courses as well on these specific IP categories of IP. All right.
Yeah.
Okay. Thank you,
So
Manya. Thank you, everyone.
thank you so much, ma'am. So let's proceed towards the second part of our session, which is the session on trademarks. So I would like to check if Arushi ma'am is here. Arushi ma'am, are you there?
Yes, yes,
Yeah.
yes, I'm here. I'm
Uh,
here.
so I would like to welcome Arushi ma'am to this session and I would like to introduce her. So Arushi ma'am started her career as a litigating advocate who eventually found interest in the field of intellectual property laws. Soon gaining experience at Singhani and Partners as associate, she moved to Arnes as the head of intellectual property and media laws division, where she was promoted to the post of partner. Mann is currently leading her own firm, Satyaki Legal, which is a full-service intellectual property laws and media law firm. During her experience, she has rendered opinions to national as well as international clients in various aspects of intellectual property, including prosecution of applications for trademark, design, and copyright registration. She manages IP portfolios of various multinational and national companies. She also advises her clients in all-round services of media and entertainment sector. So ma'am, we are like very delighted to have you with us today. And I personally like she is the most kindest speaker I have ever talked to. So welcome you ma'am to the session and thank you for accepting our invitation.
Thank you so much, Manu. That's very kind of you to say that. So I think Charu had given a very good intro session. So most of you must be aware of what trademark is, right? So I'll quickly start with the presentation. This time, my presentation is not as interesting as it usually is, but I've tried. I just had to got a little busy, so couldn't do much with the presentation. So I'll share it any which way. आज हम boring presentation से काम चला लेते हैं.
I'm sure, Arushi, they will have a lot of questions for you on trademark. You might
Yeah,
not be
because
able to finish your PPT also.
I am pretty sure about that as well. Let me see. So I've tried sharing, I've tried to discuss both the filing in India as well as Madrid, right? But we'll just start with the basics first about what actually is a trademark. So, in going by the layman language, it's anything and everything that gets defined as a brand name, be it a small label which denotes a popular brand, or it could be the name itself, right? So, or sometimes it's a particular sound that's popular in the advertisements. It could be anything, right? It could take different forms, uh, labels and names, combination of colors, most of anything that helps you recognize the brand, right? The source of the product. So a brand is basically denotes the source of a product, where which company or which particular brand it's generating, it's originating from. So all of these are basically covered under a trademark. Right. So the governing law in India is the Trademarks Act of 1999. Uh, Here, the just I'll just tell you the section, right? I don't like we usually like going into the particularities of the law, but yes, there are two different definitions. One is of 21M, which talks about a mark, right? And 21ZB talks about what actually is a trademark, right? When a trademark is capable of when a mark is capable of being represented graphically in India, we have this particular precondition for a trademark. So it then the mark becomes a it's then that a mark becomes a trademark, right? So like just to brief of what the governing law is and what are the provisions which define trademark is something that I'm discussing here, right? I wouldn't want to go into the nuances of it, is because then we might just miss out on more particular parts of the presentation and the procedural part also. So when we talk about what actually can be trademarked and what cannot, right? So पहले ऐसा करते हैं, we'll start from you guys, like what is it that you guys think can be trademarked and what cannot be. When I say that it has to be something so distinctive that it helps you recognize the brand. So, what do you think? What do you think can be trademarked, and what is something that you wouldn't want to trademark? I've stopped sharing my presentation so that I can get a few answers. So that basis on the basis of those answers, we can take the discussion ahead. We have raised a hand by Shivam. Suyash.
Good evening, ma'am.
Hmm.
Ma'am, so I think that if something is very generic and commonly used, that
Mm-hmm.
cannot be registered as a trademark, but something which is very distinctive and only that brand is associated with it,
Mm-hmm.
it can be used as a trademark. For
Fine.
example, the Apple logo, it's
Right.
very different and only one brand uses it.
Right. Okay. We're reaching somewhere.
Ma'am,
Who
according to
else?
me, that ma'am, can you hear
Suyash.
me?
Yeah. Please tell me. I can hear you.
Ma'am, Airtel jingle can be used as a trademark. I think it's different that Airtel can be recognized by its jingle.
Mm-hmm. It is different. True.
I
So
mean,
would. Mm-hmm.
I'm saying that it can be used as a trademark because I mean, when you hear the jingle, you recognize only one brand called Airtel.
Right, right. Similarly, you can also give an example of Nokia's ringtone or Yahoo's Yodel for that matter.
Yes,
All of these
yes,
things,
ma'am.
they are distinctive, right? The minute you hear them, you immediately recall a particular brand. So things that help you connect to the particular brand, right? The originating source of that product or the service, the originating service, of that particular service. So वो जो sources होते हैं ना, the 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 aspect, the factor that helps you, recall that source, right? That is what actually helps recognize a brand, and this is what something that is a trademark. So like Shivam said and like Suresh said, it is actually something that it is not generic, it should be something distinctive, right? So all of these things, they help you recognize recognize a trademark, right? So just give me a second. I'll start sharing my screen again. So yeah, what is it that you avoid? We avoid terms which are generic in nature. So you cannot call your the brand of chairs as chair, or you cannot call your brand as cup. If you're trying to sell clothes, you cannot call it as kapda. And Shivam, जैसे हमने एक example दिया ना Apple का, so it's because you're selling electronics, you can call it Apple. Had it been fruits, you couldn't call it Apple, right? So that's the basic point. It's not related to the
Yes, ma'am.
industry where you're selling the product, right? It cannot be descriptive. When we talk about descriptive, it means defining the kind or quality of your product. So chocolates are usually sweet, so you cannot call your chocolates sweet, right? So all of these things, your terms cannot be deceptive in the sense, suppose you have a brand called Lakme, not suppose, we have a brand called Lakme, right? You cannot have something which is very phonetically similar like me for cosmetics, right? um, as per the law, we do not use flags, armorial bearings, official hallmarks, and emblems without legal authorization, right? So, and any term which is opposing to, or contrary to public order and morality, again, that is something that you cannot have as a trademark, right? So, when we talk about trademarks, different kinds of trademarks. Abhi mein we've discussed Apple ka logo, something that Shivam told us. There is a jingle, right? This, particular sounds that we've discussed, which denotes trademarks, right? So there are different kinds of trademarks. In India, there is a precondition, like we discussed in the previous slide, not elaborately though, that it should be capable of being represented graphically, right? So that's something we'll discuss in the forthcoming slides as well. So when you have word, it's Apple, right? But when you talk about that logo in particular, it becomes a device mark, like the one of Lacoste, right? Service marks, service mark can be a word mark also and a device mark also. When we talk about service mark as such, is about providing services, right? That's another category of marks. When we talk about sound marks, I'm not sure if this is going to play, but I'll try and play it for you. This is a Yahoo's Yodel. So this is a particular sound. I'm not sure. Were you guys able to hear it?
Yes, ma'am.
Yeah, so this particular Yahoo's jingle is the one that is trademarked, right? So जैसा सुयश ने हमें बोला कि हम एयरटेल को उसके पर्टिकुलर साउंड से पहचानते हैं, हम नोकिया के साउंड को पहचानते हैं. So all of these are actually, kind of trademarks. These are sound trademarks. Moving on, we also have collective mark, certification mark, color mark, shape mark. Now I'll tell you what collective mark is. So we have the example of CA. So CA is a particular organization which denotes a particular set of professionals. तो ये जो मार्क है ना, ये कलेक्टिव मार्क है, ठीक है, ये एक पर्टिकुलर कैटेगरी होती है मार्क की. दिस डजंट मीन दैट a collective mark cannot be a device mark. It's a device, it's a logo, right? Certification mark, ISI, AG mark, all of these are certification marks which particularly denote a pre-decided quality of a product, right? Color mark, usually single color को कभी भी recognize नहीं किया जाता as trademark, but
Ma'am,
John Deere, yeah,
ma'am, can you please tell about smell mark?
sorry,
Smell mark.
smell mark. You're talking about smell?
Yes, ma'am.
Yeah, give me a second. I'm coming to that. So color mark,
Uh,
yeah,
I'm sorry to interrupt, ma'am. I would like to request all the participants to please like put your question in the chat box. That would be better because it is creating a little interruption. If you have like ma'am will be covering the topics, and after that if you have the same doubts then you may ask. That would be better. I
yeah,
think
yeah. We
ma'am.
can
I'm
discuss
going
it
to
in the end
suggest.
also. No problem.
Yeah.
And I think that's more
Okay, ma'am.
convenient also. So when we talk about color mark, usually क्या होता है ना, color किसी particular color की combination को ही हम recognize करते हैं as a color mark, right? But here John Deere is one of the special marks. So which is जिसका yellow is recognized as John Deere's yellow. Similarly, Cadbury's Pantone shade जो है of purple, right? That is also one of the trademarks. I think it has been recently refused by European Union, but I'm not sure. I think it is. Coming to shape mark, I think you all can recognize this particular product. Can you?
Ma'am, it's Toblerone, I guess.
Yes, it's Toblerone's chocolate. So Toblerone's chocolate, क्योंकि वो Toblerone के साथ साथ you recognize these mountains also, right? Mountain range also. So this is why it's a shape mark. Nobody can copy this particular shape for chocolates or any other product if they can imagine can have the shape. Okay, so these are the particular types of trademarks. Moving on, we have smell mark. Smell mark is for Play-Doh. Clay. Is it recognized in India? No. Taste mark? No. As of now, there has been no application for taste mark. There's a hologram mark for American Express का जो hologram होता है वो. Motion mark. I've not used the video here, but when you switch on the laptop and you have a particular motion of Windows emblem, that particular mark has also been registered as a motion mark. Now talking about smell mark and taste mark, right? Somebody that pointed out a question. वापस जाते हैं and we talk about the definition. What is a trademark, right? So एक तो हो गया mark, एक हो गया trademark. What is the precondition? The precondition is that it should be capable of being represented graphically. Right, so smell and taste is something that cannot be represented graphically. Also, retaining that smell or a taste for a particular period of examination would deteriorate the taste or smell any which way. So these are a few arguments that revolve around smell mark and taste mark, and that is why there aren't a lot of applications, or there's not there, even though there's an ongoing argument about it, but then basically people find it very difficult to trademark. Right. Now, I'm pretty sure the first question that comes into mind is कि अगर motion अगर हमें graphically represent करना ही है तो हम sound को कैसे करेंगे? तो I think it's pretty easy to guess that the notations जो होती हैं हमारी, they help you. The graphical notations होती हैं music की, right? So it has to be submitted in that form as well. So हम graphical notations के साथ साथ we submit the sound along with it, and that's how the application for a sound mark is set, right? Purpose we've discussed. We identify the origin of product and service. It helps you distinguish with the ones prevailing in the market, and it guarantees you particular quality, and it's also a form of advertisement, right? That's a particular hashtag of the firm also that we follow, that it's protect to promote. Usually what businesses do is that they first promote themselves and then they seek protection, because the infringement begins the minute promotion begins. Ask any of the Shark Tank startups, you guys will realize किसी को भी अगर आप किसी भी Shark Tank के contestant को जानते होंगे, they are troubled by immense infringement and copying of their products and brand names and whatnot. So it's always first protect and then promote. Benefits, again, prima facie evidence of proprietorship, right? It gives you exclusive right to use the trademark, right? It helps you. The minute you get an exclusive right, you also get the right to take legal action against somebody, right? You also have the authority to assign and license your trademarks, right? And you can enjoy the goodwill, right? And you have to keep renewing for that your trademark time from time to time, right? So goodwill, say what is it that you think you can attain once your mark attains certain goodwill? What is it that you will reap out of it? Any idea? मैं ये आंसर कर दूं? Once your mark attains certain amount of goodwill, right? What is it? What is the benefit that you reap out of it? This is my question.
Ma'am, am I audible?
Yeah. आपकी आवाज तो बहुत धीरे आ रही है, but sure you can answer the question.
Does this have anything to do with branding?
Of course, your brand worth increases, but what is the benefit that you get? Aranya has raised the hand. Anybody can answer, either of you, here or Aranya.
Hi, ma'am. So when you have a registered trademark, it sort of creates a brand value for you. And when that brand value is utilized to increase your growth and increase your sales or anything along those lines, uh, when you're trying to sell a product or when you're uh,
देखो
I,
क्या होता है ना, जब किसी प्रोडक्ट की गुडविल बढ़ जाती है तो क्या होता है
Ma'am, excuse me, ma'am.
Yeah,
Valuation of the business increases, ma'am.
absolutely. Who was this? Who answered this question? Savita.
Yeah, ma'am.
Yeah, so Savita answered this question, right? Good.
Yeah,
Very good.
ma'am.
What happens is,
Thank
once your goodwill starts increasing, right? जब गुडविल बढ़ती है तो आपकी ब्रांड वर्थ बढ़ती है, उसकी वैल्यूएशन बढ़ती है, जिसका इवेंचुअल बेनिफिट दैट यू गेट इज असाइनमेंट और लाइसेंसिंग के टाइम पे you become more valuable. It's the monetary aspect of your brand, right? So there are two aspects of brands. One is the right that you exercise for availing the benefits, and the other part of trademarks exercising of your right is preventing, right? It's a negative right. इसको हम negative right बोलते हैं law में, that not only do you have your right, you also prevent other people from taking away that right. Now do you get my point? So जब हम goodwill की बात करते हैं ना, it's a positive right. Positive right means exercising your right in the sense that that the value increases, the goodwill of your brand increases. तो वो goodwill बढ़ती कैसे? Negative right को साथ में associate करके, कि आप किसी और को, आप मार्केट में आ भी गए और आपका ब्रांड रजिस्टर्ड भी है, ठीक है, बट अगर आपने और लोगों को प्रिवेंट नहीं किया उसे कॉपी करने से, योर ब्रांड विल गेट डाइल्यूटेड. सो exercising the goodwill in form of assignment and licensing comes into picture once you've exercised your right in positive form, and also by exercising your negative right by preventing others from using your brand, right? Now do you guys get my point? Apple might get as much bashing as they want for filing a case against Prepier, right? Guys must have read this case, जिसमें किसी ने अपने प्रेशर कुकर्स को लॉन्च कर दिया था, उसका नाम था प्रीपियर, PREPAR. उन्होंने प्योर को टिल्ट करके लगा दिया था, just like Apple's Apple, but it was not a bitten pear, and also very small brand, even though it calls for a lot of us, like even I judged it as bullying the small traders, but then you have to be as vigilant as that, in stopping people from copying something that's even remotely similar to your brand. And that's how these brands attain that high amount of worth. Okay, so moving on, uh, what else we're discussing? So now we're discussing the steps and procedure. You select a trademark, you create it. ठीक है, create करने के बाद there is a step called class selection. Then there's the thing called trademark search. Then you file an application, there's a form and fees for it. You respond to office queries and then you obtain registration, right? Now we'll discuss all of these stepwise. Selection of trademark and creation of trademark is something that we've discussed. It should be something unique and not related to your brand, distinctive. It could be sound, device, anything, all the lines that we've discussed. Moving on comes to, we have classification. So there's a nice thing called nice classification, right? Very closely associated to trademarks. इसमें क्या हो रहा है, you have 1 to 34 and then you have 34 to 35 to 45. 1 to 34 defines certain goods and 35 to 45 is services. I'll give you a picture of it. It's very easier to understand. So इसमें क्या होता है, if you're basically filing the trademark for, suppose, let's say chemical products, you go with class 1. If you have clothings and footwear, you go for class 25. If you have services like education and entertainment services, you file in class 41. So once you file the trademark, like Charu is discussing, it's not just territorial in nature. इसमें ना classes restriction भी होती है. क्लास रिस्ट्रिक्शन किस टाइप होती है कि जिस क्लास में हम फाइल करते हैं ना, आप राइट सिर्फ उसी क्लास में एक्सरसाइज कर सकते हैं. The exception to this rule is well-known trademarks. Once you obtain the status of well-known trademarks, then you get a cross-class protection, which means that Apple अगर इलेक्ट्रॉनिक्स भी है ना, तो वो प्रेशर कुकर सेल करने वाले को भी रोक सकता है. फेसबुक अगर सोशल मीडिया है ना, तो वो बेकरी को भी रोक सकता है. Okay, this is the whole point. So the exception to rule of the limitation of class protection and to an extent territorial protection is well-known trademarks, right? Now we come to appropriate forms and fees. It's form TMA for filing the application, right? The fees is if you're an individual, startup or MSME, you pay 4,500 or 5,000. 5,000 is for physical filing. The government gives you an incentive for and to encourage an online filing, and by giving you a discount of 10%, which makes your fees as 4,500. If you're any other entity other than individual, startup and MSME, so if you're a company, which means a body incorporate, or if you're a partnership, if you're an LLP, if you're all of those, right, then your fees is 10,000 for physical filing and 9,000, which is a 10% discount, which is 10% rebate. 1,000 minus हो जाता है आपकी 10,000 में से, fees becomes 9,000. How does your form look like? I have a few screenshots. So this is one particular reason why I did not change the presentation, because there are n number of screenshots in this presentation, which helps you understand the practicalities of trademarks. So this is how the first page of your application looks like. You have TMA here, right? You select the form, you select the type of applicant, which means you're either an individual or a sole proprietor, startup, small enterprise or others. Small enterprise का मतलब होता है MSME. सो क्वेश्चन आ सकता है कि अगर हम कंपनी हैं तो क्या हम स्टार्टअप नहीं हो सकते? अगर आप कंपनी हैं, अगर आप पार्टनरशिप हैं, LLP हैं और आपके पास स्टार्टअप रिकॉग्निशन है फ्रॉम द गवर्नमेंट, which means DPIIT का रिकॉग्निशन है, then you will fall under the category of startup and not a body incorporated, so that you can avail the benefit. This is one of the benefit of startup. Yeah.
Ma'am, recognition by which body did you just say for startups?
It's called DPIIT. डिपार्टमेंट. हाँ, राइट. उसके बाद हम सिलेक्ट करते हैं ट्रेडमार्क्स एप्लीकेशन. देयर आर एन नंबर ऑफ एप्लीकेशंस. सी, अब अगर हमें कलेक्टिव मांगे सर्टिफिकेशन मार्क्स सिलेक्ट करना है तो दूसरी कैटेगरी है, नीचे अलग से आती है. यू कैन ऑल्सो फाइल अ मल्टी क्लास एप्लीकेशन, विच मीन्स यू कैन फाइल फॉर मल्टीपल क्लासेस इन वन एप्लीकेशन. फीस मल्टीप्लाई हो जाती है, फीस कम नहीं होती है. सो योर फीस इज 4,500 पर क्लास. ओके, इट्स नॉट पर एप्लीकेशन, बिकॉज मल्टी क्लास में एप्लीकेशन एक होती है बट क्लासेस मल्टीपल होती है. ठीक है. सो हमने अगर ट्रेडमार्क एप्लीकेशन सिलेक्ट किया, नीचे हमने क्लास डाला एंड देन यू सबमिट इट, राइट. आई विल डू दिस फुल स्क्रीन में. ठीक है. दिस इज हाउ योर एप्लीकेशन फॉर्म लुक्स लाइक. You fill in your applicant details, you fill in agent details, you fill in address for service. There's a trademark, right? You enter the class and you enter the statement of use and then you click save. अप्रोप्रिएट ऑफिस हमारे एप्लीकेंट के जो एड्रेस डिटेल्स होते हैं उसके हिसाब से सेलेक्ट होता है, राइट? जुरिस्डिक्शन आती है. सो यू हैव एन ऑफिस इन दिल्ली, you have an office in Ahmedabad, you have an office in Calcutta, you have an office in Bombay, and you have an office in Chennai, right? So इस हिसाब से हमारी jurisdiction decide होती है. So quickly going through the procedure, your application by now has been filed. An application number is allotted to you. ठीक है? Application number allot होने के बाद क्या होता है? Application number immediately allot हो जाता है, right? The minute you submit and sign your application and pay the fees, application number will be allotted to you. One of the things that application goes through a check is called as formality check. Formality check means procedural requirements जो भी हैं, power of attorney अगर जरूरत थी तो फाइल हुई या नहीं, आपने क्लासेस ठीक एंटर किए हैं या नहीं, all of these things. If your description falls under the class that you have defined, all of these requirements वो हमारी फॉर्मेलिटी रिक्वायरमेंट्स होती है. इवन दो एग्जामिनेशन रिपोर्ट में इवन दैट कैन बी वन ऑफ द ऑब्जेक्शंस. मूविंग ऑन, वंस यूजुअली 2 months में एग्जामिनेशन रिपोर्ट आ जाती है, नहीं आती है आजकल बिकॉज आई थिंक देयर इज अ लॉट ऑफ वर्क दैट्स पाइल्ड अप विद द रजिस्ट्री. So usually 5 to 6 months we get an examination report. So now there are two categories of the to it. One is no objection and one is an objection. Objection आया, it could be a 9 or an 11 objection. So guys can note down, there's a section 9 objection, there's a section 11 objection. Section 9 objection is known as an absolute ground of refusal. Section 11 is known as relative grounds of refusal. Broadly telling you, section 9 की objections होती हैं आपका मार्क जेनरिक है, डिस्क्रिप्टिव है, एक्सक्लूसिव नहीं है. Section 11 की objections होती हैं that there is some other mark that is existing on the register or under the application process which resembles your mark. So your mark is not capable of being exclusive, right? इसलिए वो relative ground है कि absolute ground है. You file a reply to that examination report, right? The reply has to be filed within 1 month from the date of examination report, right? A lot of times, if the reply is well drafted and the examiner has gone through your reply and is satisfied with your reply, usually the application is not marked for show cause hearing, right? But earlier I was under a pretext that section 9 objections will always land up in show cause hearing, but most recently we filed a reply to a section 9 objection, which is an absolute ground of refusal, and the examiner was satisfied and the mark got accepted without hearing, right? वरना जो hearing होती है उसे हम SCH बोलते हैं हमारी लैंग्वेज में, which is a show cause hearing, right? शो कॉज हियरिंग के बाद आपका मार्क या तो रिफ्यूज होगा या एक्सेप्ट होगा, जो नो ऑब्जेक्शन के टाइम पे एक्सेप्टेंस का आ जाता है. एक्सेप्टेंस के बाद योर मार्क गेट्स पब्लिश्ड इन द जर्नल. व्हाट जर्नल इज इट? इट्स अ ट्रेडमार्क्स जर्नल अवेलेबल ऑन द रजिस्ट्रीज वेबसाइट. ठीक है, आईपी इंडिया के पेज पे. जर्नल में पब्लिकेशन होने के बाद जो ये एग्जामिनेशन प्रोसीजर होता है ना, ये इंटरनल प्रोसीजर होता है ऑफ द रजिस्ट्री. जब जर्नल में पब्लिश हो जाता है, द मार्क इज ओपन फॉर ऑपोजिशन. It's a terminology difference, and this is something that every law student or the the practicing lawyers of IP should know. वो अक्सर objection और opposition को interchangeably use कर देते हैं, which is very wrong. Opposition is a third party thing. Objection is an internal examination that takes place within the registry. Okay, so an opposition is a third party objection, right? So जो opposition आती है वो third party से आती है. अगर opposition आने के बाद there is an entire different procedure that takes place. Those are known as opposition proceedings. Headings बता देती हूँ उसकी. It's a very long discussion. There's an opposition. There's a counter statement. There's an evidence in support of opposition. There's an evidence in support of application. जो applicant होता है जिसका mark oppose हुआ है वो evidence file करता है. There's an additional evidence by the opponent. 5 steps. 6th step is the hearing. Takes you good 5 to 6 years of process. But do you stop using your mark during that process? No. You can always write TM and keep using your mark. If your mark is not opposed, after 4 months of publication in the journal, going back to the journal wala step, right, your mark gets registered. What is the date of registration? The date of registration is the date of application. ठीक है? Registration के बाद, you after 10 years from the date of application, your mark is due for renewal. Interesting thing, I have one of my clients जिन्होंने application 97 में file किया था. Okay, and very interesting case. What happened is his mark got opposed in 2004. The opponent later on wanted to settle the matter. The applicant didn't want to, our client didn't want to settle the matter. What happened? The matter went in abeyance, and now in 2022, the client came up to me and he said, "इसको तो आप कैसे भी ना register करा दीजिए." Luckily, on 15th of August, when we were celebrating Azadi Ka Amrit Mahotsav, the registry called in for applications for settlement, the ones that have been in abeyance for years. We filed that request and now it's up for hearing. The question that comes into picture is, what if the mark gets registered? What date will it be registered from? 97. How many renewal fees will have to pay? Will it be due? So that's one question I'm yet to ask the examiner, because this has never happened in front of me. I will accept it, it has never happened in front of me. But as per, this happens in patent a lot. That registration जब तक grant होता है, उसकी renewal का time आ जाता है patent की. So you file the renewal fees and there is a annuity that you have to pay for patents. तो वो जितने साल में भी examination and hearings and all this procedure was taking place, no, you have to pay annuity for all the years. So that's how I have the knowledge that as अगर हम patent का same procedure follow करेंगे, तो trademark में भी we will have to pay the fees. कितने साल हो गए 2022 से लेके 97 तक? बहुत सारे साल हो गए ना. I think we'll have to pay fees for 2 renewals now. So this is what happens. Sometimes things will come into your notice. So it's 25 years, yeah. We'll have to pay the fees for 20 years, which is 2 renewals. So this is what happens, and it's very interesting to see such cases. अब आ जाते हैं international system पे. There's a thing called Madrid system. Aware of it?
Yes,
पता है?
ma'am.
पता है? क्या पता है? What is it that you know about Madrid system? Don't read the slide,
It is
okay? Just answer.
it is meant for the international application filed for many countries in a single application.
Yes. By means of one single application through a Madrid system, you can file for different countries. They do take money in that form as well. ऐसा नहीं है कि they will charge you for like a single application or something. There's an international procedure for calculating that fees as well. Which departments or which organizations or institutions, whatever word you want to use, they administer. So there's a thing called International Bureau of WIPO. Okay? That's the governing body. They administer it basically. Very active body. So they're very, very helpful. Agar आप WIPO खोलेंगे and you read through the procedure, it's a very helpful procedure. They help you calculate fees also. And if nothing works, you give them a call and they will make you, sit down on the computer and guide you step by step of how the application procedure is going to take place and how you calculate the fees and pay and, help you complete all the formalities. That's one thing that I've done myself, so I can tell you about that. Right, so in 2013, it's when that we acceded to the Madrid Protocol. Okay. So who can file it? Any person which is a legal entity, right? You are a citizen or is domiciled in a country which is a member of Madrid Protocol. You have a registration of a trademark, right? Or who has filed an application for registration of trademark in that country. ठीक है, मैड्रिड कंट्री में आपका एप्लीकेशन होना जरूरी है. ठीक है, the application for international registration is made by the same person for the same trademark and in respect of goods or services covered in domestic application or registration. तो ये पॉइंट इंपॉर्टेंट इसलिए है इज बिकॉज आपका जो एप्लीकेशन है ना, इंडियन एप्लीकेशन, सपोज अगर हम यही एग्जांपल लेके चलते हैं दैट यू हैव एन एप्लीकेशन इन इंडिया एंड यू वांट टू फाइल एन एप्लीकेशन अब्रॉड, तो जो आपका इंडियन एप्लीकेंट है वो, और जो आपका मार्क है एज इट इज वो, और जो आपका गुड्स है वो, these three things get tied to your international application the minute you file for an international registration through Madrid protocol. ठीक है, ये से हम बेस एप्लीकेशन बोलते हैं, ये हमारी सोर्स एप्लीकेशन होती है in you know the language of practicing lawyers. So this is our base application जिसके बेसिस पे हमारा इंटरनेशनल एप्लीकेशन फाइल होता है. ऐसा नहीं है कि हम इंटरनेशनल एप्लीकेशन को अमेंड कर सकते हैं. ठीक है, इंटरनेशनल एप्लीकेशन अमेंडेड फॉर्म में कैसे फाइल होती है, तो आप इंडिपेंडेंटली उन कंट्रीज में फाइल कर रहे हैं, यहाँ से कोई कनेक्शन नहीं है. बट अगर आप यहाँ के प्रोटोकॉल और यहाँ के प्रोसीजर के थ्रू कर रहे हैं देन यू हैव टू यू नो उसमें एप्लीकेशन नंबर एंटर करके यू हैव टू गो बाय द डिटेल्स ऑफ योर बेस एप्लीकेशन. ठीक है, ब्रीफ प्रोसीजर. आपने एप्लीकेंट ने फाइल किया, ठीक है, एप्लीकेशन. ऑफिस ऑफ ओरिजिन क्या होता है, मतलब सपोज यही एप्लीकेशन लेके चलते हैं हम कि हमने इंडिया से फाइल किया, तो हम ऑफिस ऑफ ओरिजिन हो गए, हम वेरीफाई करेंगे एप्लीकेशन को. ठीक है, आईए का मतलब वो इंटरनेशनल एप्लीकेशन. ठीक है, एंड वी सेंड इट टू द रजिस्ट्री विल सेंड इट टू इंटरनेशनल ब्यूरो ऑफ वाइको. वो क्या करते हैं, वो एक फॉर्मेलिटी एग्जामिनेशन करते हैं, और जब आपकी एप्लीकेशन सही होती है वो उसे वाइको की गजेट में पब्लिश कर देते हैं और उसे हम डीसीपीज में भेज देते हैं. ठीक है, डीसीपी क्या होता है, डेजिग्नेटेड कॉन्ट्रैक्टिंग पार्टीज. तो ऑफिस ऑफ ओरिजिन होता है जो हमारा होम ऑफिस होता है जहाँ पे बेस एप्लीकेशन है, और डेजिग्नेटेड कॉन्ट्रैक्टिंग पार्टीज होती हैं जिन कंट्रीज में हम एप्लीकेशन फाइल करने के लिए दे रहे हैं. ठीक है, सो यू उसके बाद क्या होता है, जो हमारी डीसीपीज होती हैं वो हमारा एप्लीकेशन को एग्जामिन करती हैं. ठीक है, उसके बाद कैसे और उसमें लॉ अप्लाई होता है ईच कंट्री का, लाइक चारों बोल रही हो कि ये टेरिटोरियल लॉ है, तो वो अपनी टेरिटरी के हिसाब से उसको एग्जामिन करते हैं. ठीक है, और हमारा जो प्रोविजनल रिफ्यूजल होता है ना, जिसको हम एग्जामिनेशन रिपोर्ट बोलते हैं इंडिया में, उसे हम इंटरनेशनल में मैड्रिड प्रोसीजर में प्रोविजनल रिफ्यूजल बोलते हैं. ठीक है, सो वो एग्जामिनेशन रिपोर्ट जो होती है स्लैश प्रोविजनल रिफ्यूजल, वो वाइको को कम्युनिकेट करते हैं. ठीक है, इन केस ऑफ ऑब्जेक्शन दे गिव प्रोटेक्शन, इन केस ऑफ नो ऑब्जेक्शन वो प्रोटेक्शन ग्रांट कर देते हैं. उसमें ना रजिस्ट्रेशन नहीं होता, उसे हम बोलते हैं प्रोटेक्शन ग्रांटेड. यू डोंट रजिस्टर द मार्क इन अदर कंट्रीज, जिसका बेस एप्लीकेशन इज इंडिया. यू ग्रांट प्रोटेक्शन, दैट्स द टर्मिनोलॉजी दैट यू यूज. ठीक है, अब इसमें आईबी क्या करता है, द मिनट प्रोविजनल रिफ्यूजल निकल के आता है, आईबी विल इंटीमेट इट टू द ऑफिस ऑफ ओरिजिन एंड ऑफिस ऑफ ओरिजिन विल इंटीमेट इट टू द इंटरनेशनल एप्लीकेंट. ठीक है, और वो मेंटेन करता है पूरे पोर्टफोलियो को, सारा फीस भी हम वहीं से कैलकुलेट करते हैं. ठीक है, अब अगर इंडिया है हमारा ऑफिस ऑफ ओरिजिन, एग्जैक्टली व्हाट आई टोल्ड यू, एप्लीकेशन मस्ट बी फाइल्ड थ्रू द गेटवे. ठीक है, ऑनलाइन फाइलिंग होती है. आई शो यू द फॉर्म इन फोर्थ कमिंग स्लाइड्स. ठीक है, टीएमआर उसको उसमें हमारी ना हैंडलिंग फीस होती है. ठीक है, जो रजिस्ट्री हमें चार्ज करती है विच इज 5000. ठीक है, एलिजिबिलिटी को वेरीफाई करता है, बेसिक रजिस्ट्रेशन एप्लीकेशन को भी वेरीफाई करता है. मोस्टली वी रिकमेंड फाइलिंग द एप्लीकेशन विच आर रजिस्टर्ड इन इंडिया. ऑब्जेक्टेड एप्लीकेशंस को हम कभी रेकमेंड नहीं करते कि वो उसको इंटरनेशनली फाइल करें. करेंगे कैसे, आप खुद इंडिया में ही ऑब्जेक्टेड है, देयर इज नो बेस एप्लीकेशन टू फाइल. ठीक है, इंटरनेशनल एप्लीकेशन प्रॉपर नहीं होती है तो टीएमआर ही हमें एक डेफिशिएंसी लेटर भेज देता है. ठीक है, हम डेफिशिएंसी लेटर का रिप्लाई बनाते हैं, अपलोड कर देते हैं विद सपोर्टिंग डॉक्यूमेंट्स. ठीक है, एंड ऑल दिस हैपेंस थ्रू द गेटवे, इट्स वेरी यूजर फ्रेंडली. व्हेन इंटरनेशनल एप्लीकेशन इज प्रॉपर, टीएमआर उसको सर्टिफाई करता है, ट्रांसमिट कर देता है वाइपो पे. फी फॉर इंटरनेशनल एप्लीकेशन एंड इंडिविजुअल फी, कॉम्प्लीमेंट्री फी फॉर डेजिग्नेटेड कंट्रीज. ठीक है, ये wherever applicable is to be paid directly to IB. एंड एक तो होती है हमारी हैंडलिंग फीस, एक होती है हमारी डेजिग्नेटेड कंट्रीज की फीस जो वाइपो हमें कैलकुलेट करके बताता है, विच इज पेबल इन स्विस फ्रैंक्स एंड इट हैज टू बी पेबल डायरेक्टली टू द इंटरनेशनल ब्यूरो ऑफ वाइपो. ठीक है, and then WIPO examines the application. Irregularities के लिए again it intimates us through that gateway जिसका फॉर्म मैं अभी आपको दिखाने वाली हूँ, and then you get intimated and you submit your reply. ठीक है, and if the application is proper then WIPO उसको ट्रांसमिट कर देता है डेजिग्नेटेड कॉन्ट्रैक्टिंग पार्टीज को. दिस इज हाउ द पेज लुक्स लाइक. इसे हम IAOI का एक टैब होता है, उसे सिलेक्ट करते हैं, वहां से इसे हम MM2E एप्लीकेशन बोलते हैं. दिस गेट्स फाइल्ड. ठीक है, दिस इज हाउ द फॉर्म लुक्स लाइक. ये हमारे ड्राफ्टेड फॉर्म्स का पेज होता है, ये हमारा पेमेंट फॉर्म्स का पेज होता है. I did all of this for the presentation only. इरेगुलरिटीज हम यहाँ से चेक करते हैं. ठीक है, और ये हमारा रिप्लाई ऐसे तैयार होता है. ओके, व्हाट हैपेंस व्हेन यू आर अ डेजिग्नेटेड कंट्री. सो सपोज किसी अमेरिकन क्लाइंट ने हमारे अमेरिका में एप्लीकेशन फाइल किया एंड देन मैड्रिड प्रोटोकॉल. फॉरेनर्स डू दिस अ लॉट. सो इंडिया डेजिग्नेटेड कॉन्ट्रैक्टिंग कंट्री बन जाती है और इंडिया में वो एप्लीकेशन फाइल करते हैं. The catch in this entire procedure is that whenever there is an international objection, suppose हमने इंडिया से फाइल किया यूएस में या यूएस ने फाइल किया इंडिया में. ठीक है, तो जो ऑब्जेक्शन होती है ना, अगर इंडिया में ऑब्जेक्शन आई है, वी आर द डेजिग्नेटेड कॉन्ट्रैक्टिंग पार्टी, हमारे यहाँ से ऑब्जेक्शन आई है that the mark is similar to so and so marks. Can the US attorney file the reply? They cannot. So at that stage, you will have to hire an Indian attorney who will file the reply on behalf of you. Right? Similarly, अगर हमने इंडिया से एप्लीकेशन फाइल किया यूएस में एंड यूएस में ऑब्जेक्शन आया, we will have to hire an attorney in the US where he will file the reply and appear for hearings on our behalf. Why is that so? Because there is a requirement which says that the service address should be of India. Also, attorney has to be Indian attorney. ठीक है? On receiving any opposition to IRDI, the TMR communicates to the WIPO a provisional refusal based on the opposition. The WIPO sends copy of the same to the holder. The holder of international registration may contest to provisional refusal and file counter. ये opposition के टाइम पे होता है. Objection के टाइम पे भी same procedure होता है. ठीक है? Objection वो आप करते हैं, उसके बाद जब in case of no objection वो सीधा accept होता है. Usually objection होती ही होती है. ठीक है, holder of international registration has to respond to the provisional refusal only through an Indian agent. This is the requirement. And ऐसे ही same goes for the opposition. ठीक है, there is a recent news where you read I think Justice Naveen Chawla from Delhi High Court has asked the controller जो होते हैं हमारे, that's the registrar, the head of the IP India, to pull up their socks because they've been very lackadaisical about this entire procedure where, application opposition में they've not intimated the same to WIPO and the status is not getting reflected as such. So they've asked them to, be more vigilant and, very updated and quick about responding to international applications, or else they lose the essence of international registration. तो मतलब ये मैंने बस शॉर्ट में बता दिया कि सब कुछ जो कम्युनिकेट होता है गेट्स कम्युनिकेटेड थ्रू IB, राइट, इंटरनेशनल ब्यूरो. एंड sometime Monday I think we should also have a class on the strategic management of IB. I find that very very interesting to discuss. I think if you remember हमने फैशन लॉ की क्लास में भी काफी सारे स्ट्रेटेजिक डिस्कशंस किए थे. Right. So this is the head to toe of trademarks. Rest, if you want to go through the guidelines, you have enough guidelines for Madrid filing and application filings. But the basic understanding of what can be filed and how is it to be filed is something that I always tell my interns also to go for fake filing. एक अकाउंट बनाओ, अपने आप छोटा सा, let's start a rough filing करके देख लो कैसे होती है ना. You learn how the requirements come up. जैसे well known की filing is one of the toughest filing that you have to go for. Color trademark की filing is difficult. Uh, in my career, I have been fortunate enough to have done both color filing and a well-known trademark filing, a series mark filing. All of these are very interesting filings. Some of the guidelines are very clear on the website. Some of them are very blurred, and you will have to take help of the registry or the people who've been filing the marks. So so on and so forth. Quickly, can we have questions? It's already 9:35. I guess you guys must be very tired. बताओ जी, whatever whoever wants to ask. One by one, yeah. शुरू हो जाओ. I can see Bhumi's question is a very interesting question. Who else? Shriom has very interesting question. Manya, why don't you coordinate these questions?
Yes, ma'am. Yes, ma'am. Okay. So let's proceed with the. I think, ma'am, you have answered the Bhumi's question, right?
कौन सा वाला?
Also, if a mark is registered for one particular class, we get the protection over specified applied goods only, right? And not for the whole class.
Yes, yes. For more details, you can note down there's a case called Nandini versus Nandini, popularly known as Nandini versus Nandini. One is Karnataka Cooperative Dairy, something Nandini Deluxe versus Karnataka Cooperative. It's very popularly known as Nandini versus Nandini. You can read that case. उसी में the court is basically said that you don't get monopoly over the entire class. So अगर आपने broad classification लिख भी दी है ना, तो वो तब तक grant है आपको जब तक कोई उसको oppose नहीं कर रहा या कोई objection नहीं आ रही है. You get protection only over the goods that are specified or that you are at least dealing in.
So, ma'am, one of the question by Shriom, ma'am, can there be a protection of catchphrases like taste, है best, mummy or Everest,
Yes,
LIC
yes.
जिंदगी के साथ भी जिंदगी के बाद भी.
बिल्कुल बिल्कुल. It can be jingle है basically या line है. इसमें आप कॉपीराइट भी क्लेम कर सकते हो, इसमें आप ट्रेडमार्क भी कर सकते हो. बट वेन एवर यू गो फॉर अ पर्टिकुलर आईपी ना, आई थिंक हमने पहले भी डिस्कस किया था ना, व्हेन यू गो फॉर अ पर्टिकुलर आईपी, तो जो आईपी होती है ना, उसकी एलिजिबिलिटी के साथ साथ वो किस पर्पस के लिए रजिस्टर कराते हैं ना, दैट्स समथिंग दैट यू शुड ऑलवेज रीड. सो व्हेन आई वाज वर्किंग विद वन ऑफ द लॉ फर्म्स, आवर सीनियर यूज्ड टू से दैट लॉ का ना सारा सेंस स्टेटमेंट ऑफ ऑब्जेक्ट्स एंड रीजंस में आ जाता है. तब ना बहुत खराब लगता था ये बात सुन के, बिकॉज पूरा बैरक पढ़ना पड़ता था कि यार अब तो इसका स्टेटमेंट ऑफ ऑब्जेक्ट्स एंड रीजंस भी पढ़ना पड़ेगा. But that's where you get the clarity from, and they're not wrong when they say it. It's actually true. The statements and objects and reasons will tell you why this act is actually existing. वरना ट्रेडमार्क भी आपको प्रोटेक्शन देता है, कॉपीराइट भी आपको प्रोटेक्शन, तो आपको तो लगेगा कॉपीराइट करा लेते हैं, डेथ के भी 60 इयर्स तक हमारा, उसके बाद तक the jingle will stay with us. But it's not going to serve your purpose, right? What is it for? It's going to denote the authorship, not anything about your product. So you go for a trademark there.
With this, I would like to completely agree. We should also study the jurisprudence of the subject. It gives us more understanding regarding the judgments and all, from where the legislators, the frame law-making people were thinking while making that particular act.
I heard Charu was also saying that legislators किसी particular purpose को serve करने के लिए law बनाते हैं. That's the whole point.
Yeah.
There's somebody who's also asked, can I trademark the name of my book? Yes, you can, actually.
Okay. So we'll come, we have some more questions. So do we need to engage US attorney in case of application through Madrid? In case of USPTO, engaging local attorney is mandatory?
Yes, it is. जब ऑब्जेक्शन आती है, अगर ऑब्जेक्शन के बिना ही आप रजिस्टर हो गए, सो वी वर अगेन इन माय प्रोफेशनल years when I was working as an attorney with some of the other firm, तो हमने मैरिड एप्लीकेशन फाइल की थी. That's how I know that these people at IB office are very very helpful. तो इंटरनेशनल ब्यूरो में हमने कॉल भी किया था, एंड we were granted a Britain trademark a trademark in Britain without any objection. तब तो हम, you don't need any Britain attorney, right? But yes, agar objection, so UK mark is registered and US mark has an objection. So because you have an objection in the US, you will need a US attorney for that. ठीक है ना?
So yes, ma'am, when we have another question from Devendra, can we call Madrid protocol is similar to PCT related to patent?
Yes, it is. वो भी
Does
international
a
channel है ये भी.
sorry, yeah, I'm
नहीं नहीं कोई बात नहीं.
So next question is, does agent or attorney is mandatory for TM filing in India?
No,
Trademark filing.
no. But for correct filing and accurate filing, yes.
Is metaverse a registered trademark and how is it regulated? This question comes from Pakhar.
What
Metaverse
is the metaverse? I am not sure
is
if it's registered. We'll have to do a public search and check. है ना? यही पूछा है ना?
yes, ma'am. And how is the metaverse regulated? I think we don't have any regulations as of now in particular.
मेटावर्स की रेगुलेशन नहीं है, बट मेटावर्स से रिलेटेड जितने भी हमारे डिजिटल रजिस्ट्रेशंस हो सकते हैं, ब्रांड्स हैव ऑलरेडी स्टार्टेड डूइंग दैट. इफ यू रीड द न्यूज़, नाइकी इज वेरी पॉपुलरली, up and about getting all the registrations in metaverse. So कैसे हो रहा है? वो सब डिजिटल registrations है. In the sense, मतलब registration digital नहीं है, जो classes है ना digital world से related about scientific technological measures, about virtual reality, class 9, class 41, class 42, they're getting registrations, all of those registrations done.
So we have a very next question is very specific. Does registered attorney needs to file form TMG for registration of name in registered agent list as initial code generated for 2.5 years? How can we renew attorney code after expiration of initial attorney code?
Attorney code अब हमारा एक्सपायर नहीं होता, हमारी सिर्फ DSC होती है जिसको हम रिन्यू कराते रहते हैं. ठीक है? Registered attorneys are not required anymore. I am myself, I'm not a registered attorney, right? You can always do an advocate filing. There's no requirement as such. नहीं तो जो भी हमारा फॉर्म रिक्वायर्ड है आप उसे फिल करके you can always file it up again.
So next question again from Bhumi. Is it better to file a color specific mark or file it in black and white?
Yes, so depend करता है on the mark. अगर हमारे mark का हमने कोई कलर कॉम्बिनेशन सोच के नहीं रखा है पहले से, या हमें लगता है हम उसे फ्यूचर में चेंज कर सकते हैं, it's always better to go for a black and white trademark. But what if your mark has you have a little bit of doubt कि ना इसमें objection आ सकता है या इससे कुछ similar exist करता है, but the color combination is so strikingly distinctive from something that makes your in comparison to something that makes your mark ordinary, then you should always go for a color trademark. अगर वो bland blue है फिर क्या जरूरत है, but अगर वो मैगी की तरह येलो एंड रेड का बेस्ट कॉम्बिनेशन है तो फिर डेफिनेटली, अगर वो कैडबरी का गोल्डन है then definitely. So it really depends from mark to mark. Again, like something that I don't mania, it's a very strategic call. So another class for that.
So the last question as of now from Bhumi only. Can we use the TM symbol without applying for registration, or can it be only used after application is filed and before registration?
After application is filed, before registration, of course. TM means a temporary mark.
Temporary mark. Yeah. So I think these were the questions, ma'am, as of now. So with this, let's conclude the session. To all the participants, we truly appreciate the response from all the participants. But this session was only to ignite that fire to understand, like take interest in intellectual property, what are trademarks, to give a basic knowledge. So I understand we have seen so much interest and we have seen so many questions, and you must be having more questions. So I would suggest you to read our blogs and read other blogs on internet and study about it. It's a very interesting subject. Like, it's my personally very favorite intellectual property, and ma'am also gained the interest in intellectual property laws, and she's now specializing her own firm in that. So I would like to conclude the session with this. I hope we ignited that fire of studying intellectual property in you guys, and you will be reading about it more. So I would like to thank ma'am for her precious time. And ma'am, presentation was not at all boring. It was like wonderful
I
presentation
would have made
in
it
the
more interesting, but did not get that much time. I actually had a parallel presentation also where there were a lot of. There was one time when we had a presentation for class 8 kids, and the kinds of questions those kids asked were amazing. Like you can't imagine class 8 kids could have asked those questions. मैंने उनके लिए ना बहुत छोटे छोटे presentations बनाए थे where the brand name is missing and the logo is just present without the name, so recognize करो. There were sounds, there were motions, a beautiful presentation. But then I thought कि Charu's also given a presentation, so और time भी कम था, late हो रहा था, तो दो parallel presentations ना run करने का time नहीं था, and I wanted to actually combine both the presentations and make one. I couldn't get that time. Like I told you, I just could not
yeah,
get time
ma'am.
for
Yes,
them.
and ma'am, it was very short notice also on my part, so I would like to
कोई बात नहीं, वो तो
apologize.
चलता है, that's I understand. But any day, it's welcome. If I am free, I'm available. I'll always be there for the presentation.
Thank you so much. Thank you so much, ma'am, for being like our guest speaker. And I would like to thank all the participants for their patiently listening to ma'am and Charu ma'am also. Thank you so much. Thank you so much, IP Press, for giving me the opportunity. And thank you so much, ma'am.
Thank you. Thank you. I had a very good time.